recording available to everyone. So we are right on time, and once again, I appreciate you all for joining this discussion. And I will start with a small introduction. My name is Henry Owen, and I have the pleasure of being your host for today's discussion. I'm an associate with Sambel Advocates. I practice in the banking and finance department. And I will give an opportunity to Francis first to say a few words about himself, and then Ivan.
Hello, good morning. My name is Joel Osekeny Francis. I'm a lawyer with Adil Advocates in town, and my interests are in technology law and then commercial practice. Yeah, but also land transactions too. So yeah, that's inclusive.
Okay, I'm Rutale Ivan Paul. I'm currently freelancing as a software engineer with specialty in mobile applications for Android platforms. I think that's it professionally.
All right, so just to recap our topic for today, we're going to be looking at the topic of how to protect technological inventions. And I think that the timing is not bad for us to be discussing this issue, because we know what we've experienced in 2020, more so from the software perspective, where we've had to move away from our desks and sort of analog kind of doing things to online. Of course, as practitioners in the legal department, we see that we may not move away from what we've already achieved in 2020. We expect that more and more technology will be used and incorporated in work environments. But it's not just technological invention, rather software technologies that we are referring to. We've also seen so many other technologies come up. And we also have some laws that have been passed, be it in fintech, that are supposed to sort of aid these new technologies. And our concern, or our topic for discussion today, is how is it that, how can we protect technological inventions? And our expectation is that those people that are watching us today who are innovators in some way or another, whether software, whether engineering, that they can get an idea of, if they invent something tomorrow, how can they protect it? So I'm not going to restrict this discussion to only the legal aspects of it, but I will really be soliciting our personal experience. So if you allow me to start with you, Ivan, maybe give us an idea. Do you have any experience whereby you probably dealt with an invention that you require to be protected? And what did you do in such a scenario?
Okay, thank you. Thank you, Owen, right? Definitely any idea, even outside of software engineering, if any idea that is out there needs a lot of legal protection. Not only because of the possibility that someone might steal it, but because even the people that you're working with themselves might be the same people to become your competition in the future. So I've actually prepared a small presentation in regard to this matter, if you people would indulge me. Okay, I don't know who's holding the rights for me to share my screen.
You should be able to share your screen, Ivan.
Okay, let me do that. Are we all here?
Yes.
Yes.
Okay. So yeah, when I was approached to share on this topic, I began thinking back into maybe my career and some of the things that I've come across. And I broke it down into something like this: protecting software as intellectual property, because ideally, software in itself as source code or as a working system is just it's just plain property, but the ideas behind, the ideas that make these systems work are what we are tagging as intellectual property. And I believe most of the people that are currently here or are going to be watching this have a general understanding on what intellectual property is. Just maybe briefly, let's consider this as something that is a creative, it's a creation from someone's mind, usually something that is new, something that has not been in the particular industry and is going to help solve a particular problem and therefore can be profited from. So anything in that line can be termed as intellectual property. And so when we look at software as intellectual property, we look at it in that way, in a sense of I've created this particular software and the idea behind it is my IP and I need to protect it in some way or another. And the standard ways always come up to first, copywriting. However, we will see that copywriting is usually attached to tangible products, meaning we want to see the product itself that you're copywriting. We want to look at the solution that you're copywriting. And it's treated as a creative expression of the author. The same way you would copyright music, the same way you'd copyright works of, any works of literature generally, is the same way you would copyright your software as a product. Or so if it were a book, in this case, it's software generally. And it's good, especially for unique solutions, because generally the way software is, there are multiple things that will probably end up doing the same thing. If you're looking at social media sites, or there are maybe, okay, so everyone is aware of WhatsApp. There is probably going to be something also like Telegram or, Facebook Messenger. They're all almost doing the same thing, but the uniqueness about each of those platforms, someone continue. I think someone is okay. Yeah, so the copyright grants the creator of this authoritative and creative control for people who would like to reuse this idea or people who would like to copy it. So in that case, as you, the creator of this software, you have direction and control and perspective of how people are applying the solution. It is easier for you to enforce copyright law to stop copycats. And in case someone actually copied your software, you can easily claim. You can reach out to the law and claim that someone copied your idea and then recover damages. Like I said, it's easily, copyright is easily applicable to tangible products. We see a good application for copyright law in out-of-box solutions. For example, I don't know, for those of you that work for firms or established companies, sometimes when they buy software, they will actually bring like a CD, or it used to be those days where people are using CDs or some sort of medium that is sold to you by the company that makes this software, something that you're going to buy and then install. So in this day and age, out of box may not necessarily be like a literal box, but something that you download after authorization from a particular company. So those products are copyrighted to protect themselves from all the things that we have mentioned. So that is one of the first ways, that is the most basic. And then we look into patenting. Patents are usually applicable only when your particular idea is novel, meaning it's new in the industry and it's probably a solution or a description of a solution that is completely new. Some people have not seen this particular thing before in the industry. So you get a patent to protect you from copycats and competition for a certain period of time. That is, that depends on where you are, on what the law says in the particular place where you are. It gives you exclusive rights and it guarantees a high return on investment, considering that you are the only one who is currently developing the way you are. And then it gives you the ability to resell your invention at your own price. You have the ability to license it or sell it to other people at your own price. Because you have a patent on it, other people cannot replicate by law. And just like copyright, you can pursue anyone who tries to replicate your idea. So the one thing that we are going to notice for all of these ways to protect software, it's a case-by-case basis. There isn't one solution fits all type of way of approaching these things, because there is always a reason to weigh pros and cons of each of these things. For example, copyrighting and patenting means you have to disclose what exactly it is that you're patenting or you're copyrighting. And most of these records are available publicly, meaning your idea is out there. And yes, it is protected by the law that someone will not steal it, but in the long run, still your idea is actually out there, like in very descriptive nature. So it is something that someone has to weigh versus the rest of the methods that I'm going to talk about. And then it is also important to know that we cannot simply copyright patent or patent mere idea. Like I said, you have to be as tangible as possible. And I know that's kind of an oxymoron in software, because software is not a tangible thing. But in this case, I think we mean tangible in the sense of something that can, a description of something that is almost touched, or in the sense of it's seen, people can fully comprehend what you're talking about. So if you claim someone stole your idea or someone copied it, then we have a foundation to base upon what you're talking about. Then we have now I'm getting a bit more technical here. Source code licenses. So just for everyone's sake, source code is the actual instructions that are written into the computer to direct it on what to do. And these instructions are collected to form software. So you could apply a particular license on people who want to use your software. Your license is usually non-exclusive, meaning when someone has a license to your source code, they don't have to necessarily be the only people who are allowed to access it. And it's non-transferable, meaning they cannot, because I have a license, I cannot license someone else to use the source code. And there are usually two kinds. We have copyleft and permissive, whereby copyleft means if I get software from you, if I get source code from you under a copyleft license, and I create something from it, because when we have these instructions, this source code, we can use it to build another piece of software based on what was given to us. So if I do that, I will also have to make sure that what I produce is free to use for another person who gets the same license. If, for example, maybe Symbol Advocates attained a license from me to use a social media platform source code that I developed, and they also develop their own. That product that they come up with has to be available freely to the public, just like I made mine free to the public. All they can do is make it available under the same license that I provided mine. So that is the whole copyleft thing. And then permissive is less restrictive, meaning you are allowed to make proprietary versions of the software under the license. However, there's multiple kinds of licenses and anyone can write their own because it's like a contract, meaning the conditions change. So it may be permissive, but other conditions may change about the license. And I've listed the most common kinds, like the GNU General Public License. For those of you that have used VLC Media Player, you'll see it's protected under this license. So you see you don't have to actually pay for this software, but if you developed something basing off of it, you would have to follow the conditions provided under this license. There's the Apache license, the Microsoft Public, then all the way to the MIT license. So all these are more standardized contracts that people will enter into when they want to use the particular source code. But anyone can develop their own, as long as it's enforceable under the law, you're good to go. So that is one way to protect your software. You can put it out there for people to use, but protecting it under the law using a license. And so now all the methods that we have seen so far are methods that protect your after product. You've created your software and now you want to protect your intellectual property. But then you can also protect your intellectual property even before you have a fully formed project or a fully formed source code. And that is things like IP assignment agreement. Basically here, you are signing over the intellectual property to someone else. That's what this whole thing is about. So this one is good for startup people who are starting up their companies, for startups, or for, I guess even for an individual. If there's an idea somewhere that you like, you don't just go in there and begin working without getting the rights to the intellectual property. So that is how you would protect. So you are basing on someone else's intellectual property to also develop your own, but the protection in here comes that you don't want the other person to eventually come and claim that you stole their IP. So they have to sign an IP assignment agreement. You could pay them, or whichever way you guys decide to work on this, whichever way you decide to sign over the intellectual property. But in the end, the startup or the individual has protected their property by ensuring that there's legal documentation following the assignment of the intellectual property. So it can be a technology assignment agreement, or it can be an invention assignment agreement. So technology assignment agreement is where we have someone sign over the rights to the intellectual property before the company is made. So for example, if me and Rodney were working on a startup, and then we have a bunch of other developers, other software developers, before we make this company happen, we make them sign technology assignment agreements under the specific terms that we agree on, and we know that whatever they are working on in regards to our company is property that is intellectual property that is going to belong to the company that we are going to form. And then an invention assignment agreement is if we decide that now we formed a company, then other people that we hire, developers or researchers or whatever, all their work has to belong to us. So basically, if you are hiring an employee to develop a product, you may have to make sure that the rights or the inventions that they work on are protected to be yours, provided that they are working at your request or, and at your expense. So basically, that's it. An IP assignment agreement hands over intellectual property from one individual to another. This particular value of this type of agreement is that even when later on you are looking for investors to fund your project, they will ask you to show proof that you own the intellectual property that you are trying to sell. So if you've come up with a particular software, you have to have proof that everything involved is your intellectual property, because that is your only protection, and that is the only assurance that investors have that permits them to legally invest into your company. If the foundation of the company does not belong to the company, then everything does not belong to the company. And later on, someone can come and claim that everything that you have built henceforth belongs to them. I don't know if you have been hearing about this long-running case between Google and Oracle. There's an argument that Google used Oracle's intellectual property without their consent. They are parts of the Oracle platform. I'm trying to be less technical as possible. They're parts of the Oracle platform that Google used apparently without informing Oracle, without the explicit permission from Oracle. So Oracle has licenses and different permissions, contracts under which you can use their software. And considering that these people are using the platform commercially, they definitely are supposed to be working under these conditions. But, there are very many debatable areas in the law, because every contract, I guess, has loopholes sometimes. So it ends up causing an $8 billion lawsuit for things like that. So just a small section of their platform was apparently taken without their express consent, and now they're in a $1 billion legal battle. So that's why investors are always, very wary. You have to show that everything you are using belongs to you in one way or another. And IP assignment also helps keep at bay copycats and patent trolls. So patent trolls are just basically people who are going to see your idea and then patent it before you get the chance to, or get a copyright, and then pretend that you stole their idea, and then you'll end up having to pay these people huge sums of money. You'll probably even give them stake in your company, because under the law they are protected, because they can prove that the idea you're working with belongs to them. They filed for it before you. So that's the whole idea of patent trolls and copycats. But if you have an IP assignment agreement, you can battle them. You can say, there is no way that this belongs to you, because at an earlier date, I was already signing IP assignment agreements from the people that actually own this intellectual property. And then another one is NDAs. So this is again before we develop the software, or as we are in the process. So we want to protect our idea from being stolen by other people. We want to protect the information that we have from being taken by other people. So what we are going to do is make sure that everyone working on this particular project signs a non-disclosure agreement, meaning I cannot divulge any of the information about the project outside. So there are very many, NDAs have a lot of nitty-gritties, and you usually have to understand all the surrounding terms and then go back and forth between the parties. But the general idea is, if it's confidential information being handed over to the recipient, then that person should not disclose it outside of the agreement. So NDAs are now very, very common in the soft. I think I even listed this last because it's like one of the most common things right now. Before people hire you to get onto their team, even sometimes while you're still doing interviews, they have you sign a non-disclosure just because they're going to tell you something about what they're doing. Because in the software world right now, it's just about the idea, just even knowing the idea. The tools are open. Anyone can solve a problem through multiple different ways, but the integrity of the idea, coming up with the idea in itself, is where the treasure still is in the software world. So if you get even privy to information about an idea and you spread it, someone else can beat them to market. Someone else with better resources can develop something way better. So the idea, the sanctity of your idea is your bread and butter in the software world. So yeah, that's why NDAs are currently very, very common. And when you're going to discuss anything with anyone, they want you to sign an NDA. Make sure that you don't disclose any of their information. Make sure that even the details about the meeting are not disclosed. It prevents idea stealth, and it also maintains technical security. For example, some people have you sign NDAs where you don't even tell anyone that you worked on that product. You don't, if you're a contractor, you don't tell, you can't even include it on your portfolio that, I worked on this team, because they believe in that way. If you worked on something else using the same technical know-how that you have, and that thing can be broken into by hackers, then if they find out what you worked on and it is their product, they probably can use the same skills to attack that particular product. So from the end of the person giving you the NDA, they look at it as a way to protect themselves technically. But sometimes some of these things are far-fetched. And when you are looking at NDAs, you have to weigh pros and cons. Like I said, for all these methods, when you're applying them, you have to weigh pros and cons. For example, for NDAs, there is no portfolio highlight, meaning if I am a contractor if I have a company that has worked on a bunch of products, and we have the marketability, we have a large audience, but if you make us sign an NDA that forbids us from even disclosing that we worked on this project, we will not be able to highlight your product maybe on our blogs, meaning you have cut out that particular section of the market that you could have gotten, or the publicity that you could have gotten from a contractor talking about your project. And then on the end of contractors, maybe you are an individual developer and someone says you cannot even talk about this. You don't get to have public credit. You don't get to add that onto your CV. And right now in the software world, people want to know what have you done, what are you able to do based on what you've done. So if someone says you can't even talk about this in public, then that kind of limits your ability to add into your professional achievements. So that's why when we are applying all these methods that I've talked about, we have to be careful not to try and apply a one solution fits all. We have to you have to do trade-offs for each of these methods. What do we want to protect, and what do we want the public to know? So it is always best to consult a bunch of people. You can't work on this on your own. It's always best to consult some legal authorities, and then even internally in your company, you have to know how do we go about protecting our intellectual property. And then I was also asked to talk about how to protect systems from hackers. And I guess this is kind of a derivative of protecting intellectual property, because if someone can hack into your system, then they definitely can steal your IP. So even if it's not particularly software, any other IP that you have on your system can be stolen by hackers. And first and foremost, and why I listed it as number one, is if you are in the position to always hire an expert. If you just have, a bunch of computers, maybe networked in your office, or you are just setting up a company that's going to be dealing in software. If you're going to have any network infrastructure, it's always best to hire an expert to set up firewalls for you, to build the right network infrastructure, to make sure that every user needs to have a particular account to access the system, to give different users different levels of access. And then when you're building software, you need to have the right people so that they integrate protection in the source code. So I didn't want to go into extreme detail with the integrate protection in the source code, but basically, as we are writing these instructions that feed the computer what to do, you also write them in a way that protects the inputs into your system from hackers. For example, if you have a form online, people are inputting information. As a software engineer, you have to make sure that this information is clean and it's void of any malware or any malicious inputs from hackers. There are tricks hackers use whereby if you give them a form to input data, you have your users have a form to input data. So a hacker could input a special code that could crash your database or could retrieve certain information, or could crash your front end, your website. So things like that are protected against by hiring an expert, software engineer, or cybersecurity expert. And then the biggest loophole in security when it comes to protecting your software or your already established systems is the people who are using it. The people who are using your system are the weakest link. So if you are at your farm and you have an intranet, or you have your own applications that you're using within your farm, an external party could gain access into your system by manipulating the people that already have access. Let's say Owen has a password to a computer being used at Symbol Advocates. I could trick Owen into giving me that password through multiple ways. For example, I could claim to be another person that works at Symbol. I could claim to be from IT, and I'm like, we are trying to reset people's accounts. These things have happened. Someone claims that they are trying to reset accounts because they are rebooting the system, or they are installing new software or whatever, and they want your password so that they can go to the next step. So you're probably at home on the weekend and you think IT people are working over the weekend, and then you hand over your password. Next thing you know, you're being arrested for giving away crucial information. So in as much as the system was protected, whereby they even knew who logged in at what time, someone managed to gain access because of someone who is a weak link in the system. And we also have what we call phishing. This is something that happens online. I could try and steal your password by pretending to be the site that you want to log into. For example, someone you even know, maybe now Rodney, I know Rodney. I could send them a link. Maybe it's like some sort of promotion or some sort of article, whatever I claim it is. And I say it is on maybe say Facebook. But for them to get into Facebook, I first redirect them to a dummy site that I have created that kind of looks like Facebook. And then I ask them to enter their password and username. So when they enter that into the system, my system picks that information and it stores it, and then it redirects them to the real Facebook. So someone will see themselves having to enter their password twice and not really think about it. Yet the first wall that they hit was actually a wall from a hacker. So that is phishing. People claiming to be trusted parties, like someone calling you from IT, and also training your users to properly manage their passwords, meaning make sure they have strong passwords and they change them regularly. Password hacking is one of the very, very common things. There are even standardized algorithms and that have been written that help hackers do attacks on your password. So the stronger your password is, the harder it is for someone to hack into a system by knowing your password. So a lot of people, when we talk about hacking, assume that it's, like you see in the movies, they assume a bunch of guys are sitting in a room and writing some out of this world code that is going to break down some other system. Yes, to some extent, to a very small extent, people hack by infiltrating systems, but the biggest and more realistic way that hacking happens is through the people themselves that already have access to the system. Make sure that you have good antiviruses, that you have paid for, and regularly update them. So if you have any serious information to protect on your computers, like I said, people are your weak links. Someone could be on your computer and then go to a malicious site, download a bunch of viruses, then they would come and corrupt your information, corrupt all your data. So that's the kind of thing you protect yourself against by having and installing a regularly updated antivirus. Avoid, the cracked antiviruses. If you are working in a professional setting, you pay for the antivirus and have full-time protection. Also, while all these things are well and good, there's always new ways that people are coming up with to access your systems. So make sure that your data is backed up somewhere. Make sure that you have reliable offline backups to your information. I don't know if you were active, but a couple of days ago, Google had kind of a blackout for close to 30 minutes. So that goes to show you that even the most reliable of systems is not immune to threats completely. So they may not necessarily release the actual details of what happened, but if they were being hacked, they cannot disclose. But for people like people like us who completely rely on the services provided by Google, we could not access some of the data that we had stored with them. For example, you have a Google Drive or whatever other platform that you're using. You need to have that data backed up, because imagine they had crashed completely, then you don't have that data anyway. So don't completely rely on one set of protection. Always have backups on backups. Then make sure that you regulate physical access to your machine. Not everyone should be able to actually physically touch your machine, because hacking does not always necessarily mean people are remotely accessing your network. Someone could walk into your office and just because another worker left their computer open. Make sure that your Wi-Fi network is secure. This goes again to hiring experts. Make sure that when they set up your Wi-Fi network, another person cannot just break into your network, because if they can break into your network, then they can get access to the machine that are connected to that network. And I think that's it from me. I'm going to stop sharing my screen, but I don't know if we are doing it at the end or if we are doing it now, but if there are questions.
Ivan, we shall have opportunity for questions at the end. Thank you so much for that very insightful and very practical perspective. But right now, I want to give an opportunity to Francis. Francis, we have quite a bit of good information. Ivan told us how we can protect inventions pre and even after. So he's talked about if it's something like pre, you need to refer to IP assignments, you refer to APA agreements. If the invention has already been created, we referred to patents, copyrights, and the likes.
Hold on, Owen, I don't know. I'm having a very hard time hearing what you're saying. You're breaking.
You're breaking.
Oh, okay. Let me try that again. Can you hear me now?
That's a bit better, yes.
Okay. So I sort of wanted to give the opportunity now to Francis to take us through what his legal experience is in protecting inventions. And Francis, this is your opportunity. Please guide us through those practical steps that our members can be aware of when trying to protect inventions.
Okay, thank you. Allow me to begin by making some comments about Ivan's presentation. Because I noticed some things he mentioned that I believe I need to make a few legal references to. The first thing he said, somewhere he mentioned that if you have an idea, you need to protect it. Yeah. And I would say that when it comes to intellectual property, the law does not protect an idea. Yeah. It protects the conceptualization. If the idea is materialized into a tangible or intangible asset, that is what the law protects. For example, if your idea is you want to, let's say, build a software like Zoom, how Zoom works, but you have no conceptualized expression of that idea, there's no legal protection under the law. What the law protects is that idea in a material form. Yeah, that's what the law does, not the idea itself. The other clarity I would make is, I think it's an overlap or an error on this part, but it seems to say IPs protect tangible assets or products. But then it goes back to tangible and intangible. Software is intangible, yeah? So IP would protect a hardware, maybe let's say a phone, a design of a phone. It could be a physical product, yeah? But it protects both the hardware and then a software, or intangible and a tangible asset. But the law protects both categories. You don't need to limit yourself to just tangible assets. And also copyright, you mentioned, it has a duration. It's usually 50 years. Beyond that, someone has the right, someone can actually use your property as if it was theirs. what remains, of course, under the law, what the law protects is what they call moral rights. You have a right to economically benefit from your copyright for 50 years. For example, if like a Dube did songs years ago, and then if he wants to benefit economically from those songs, his benefit lasts 50 years. Yeah. Outside that, anybody can use those songs, but what the law says is a moral right is never extinguishes. So if 50 years elapse, yeah, and someone did a song for 50 years and it has been there for so long, when it comes to enforcement, the right to recognize like a Dube as the owner never ceases. Yeah, the economic right will extinguish, but the right to call you the owner will always stay. And then patents also go for 20 years. Of course, yes, it goes for 20 years, the duration. Beyond that, it's a gray area. And then you mentioned open license. I wanted to give an example of maybe Android. I think it's an open license. So you have companies like Huawei, maybe Xiaomi. These companies manufacture phones, but every individual company has Android, but the Androids are different, yeah? So the open license from Google allows them to tap into Android and modify it to suit their different infrastructure. But the first thing is the license to use Android is free, but allowed to modify it to suit their different, to customize it to suit your needs. So you have different, should I call them skills? You have a different feel, techno, different feel from a Samsung, but they're all Androids. But Google enjoys the moral right because whenever you copy these property rights, these rights from Google, you must always recognize Google as a owner of the products. Google allows you to use them on condition that you recognize it as a, you don't have to claim you own Android. It belongs to Google. Yeah. So the moral rights always stay. And then the other thing is, yes, agreements. That's a good one. But again, when it comes to the law, an owner of intellectual property rights has several rights attached to that ownership. One of them is the right to sell. On top of us, besides assigning your interest to somebody else, its assignment could be duration, maybe 2 years or a week or a month, depending on how you want the person to use the item. But the law allows you to even sell your property rights. You can decide to create a software, like say Zoom, and then tomorrow you sell it to somebody else. You've seen software going. You've seen companies selling software to different, Instagram went to Facebook, that kind of stuff. So you're allowed to sell, license, assign, transfer, even if someone died also, that interest can succeed to the next legal representative. Yeah. So IPs also give that right to transfer ownership from one person to another. What else? Yes, you mentioned employee inventions also. Under the law, the law recognizes. Let me define an inventor. Under the law, an inventor, innovator, or a copyright owner, or an IP rights owner. Those are different terms because patents, copyrights, trademarks have different contexts for what an owner is. Yeah, but when we talk about employee inventions, let me talk. That will take me to maybe, let's say, copyrights and then patents. So if someone creates, let's say, designs a software using property belonging to the employer, usually the law says that property belongs to the employer. So you have someone designing a software using company properties, using company Wi-Fi, using company resources. That item ordinarily, on the face of it, would belong to the owner, not to the employer of the company. Yeah, but outside that, the employer has no rights over that property. But again, the moral rights come back. You're only giving out what you give out in this scenario is a right to economically benefit from the employment inventions, but the moral right always remains. Yeah, the employee, in much as it does the work and in the employment environment, it belongs to the employer. But when it comes to moral right, you must recognize the employer as the person who designed the product. even if the product belongs to the employer. Yeah. Yes, the other thing was the NDS. NDS was a good thing. Always you need to protect your now this goes back to now ideas. IP doesn't protect ideas, but an NDA can protect your idea. Yeah? So IP limits you to tangible material, materialized expressions of the idea. But when you do an NDA can actually protect your idea. So the best thing for you to always secure your interest is to sign an NDA to protect the idea before it's conceptualized. Because the moment you don't have an NDA in place, and then you go on sharing or showing off on your friends with the idea you have, someone can take the idea and create something in anticipating to create. And you don't have anything against them because the law protects the conceptualization, not just the idea. Yes, the other mention was avoid cracked antiviruses. And this takes me to pirating. Yeah, copyright protects someone's creation, works, source code, like you mentioned. And today, with technology, people tend to, should I call it steal? Pirating is stealing. You go online, as opposed to buying a software, someone getting a free version and owning it. Now, at that stage, you're depriving your regular owner to the copyright. Yeah. So it's right now, I think in Uganda, it's actually difficult for us to enforce IP rights, but the laws are in place, yeah, that protect IP rights. People continue to you've seen Howie.biz, the music industry website. So you have people going in there, picking songs for free. Then some go to iTunes and actually pay or go to Spotify and pay for it. But those who do the free version are actually causing a detriment to the original owner. So avoiding cracked software or stealing thing goes back to the enforcement of IP, enforcement of intellectual property. How do you avoid this kind of pirating? How does an owner avoid making a loss from his innovation? Yeah. What I've noticed is when you go to a site that, let's say, uploads an illegally stolen album, you'll find that when you try to download, it will tell you it's no longer available. Now, there's an enforcement mechanism. So usually when you go online and you find that someone is uploading your album without your permission, an album is a copyright, yeah, because it's musical works and stuff. So what the person, the owner of the property does, they can actually approach the owner of the website, yeah, to file a complaint. You can file a complaint with a hosting service provider, whoever is hosting the site, to actually take this item that is infringing your copyright down, yeah. If they fail, you now go for other remedies, which I'll be discussing later. But the most important thing is when you see someone is infringing on your copyright or your item online, you need to immediately file a complaint, either report to the site owners, because the sites have owners, they have contact information. You can reach out, tell them to remove this item from their site because it's infringing on the copyright or IP rights. The other could be you go to the host because the site designer might refuse to put it down, but the host also has power over the particular website. Actually, because if you don't put it down, you might actually extend liability from the website owner to even the host. So to avoid being liable for that violation, the hosting services also tend to implement these things. So at times you find some sites are temporarily offline because whatever they're uploading is illegally stolen, is illegal, because the hosting service has disabled the site from being operational. Yeah. Yes. I want to make those comments. I've discussed some parts of enforcement, but I will still do it in my presentation. I have a PowerPoint to do, though mine is mostly in patents, because when you said protection of inventions, it took me to patents, trade secrets, because now copyright won't be inventions, as I will show you later. But yes, under software, they're protectable under copyright, and even trademarks, because you need to, now the copyrights itself have, for example, if your company manufactures software, that company has a name, yeah? And the law protects the identity of the company. So that is what trademark does. Trademark protects the identity. What identifies a company from another is a trademark. the name, the sound, the label, etc., the logo, all the things are trademarks. Then copyright are what you discussed. Software is majorly copyright. But of course, there are some elements of trademarks. We've also noticed that some software or some hardware, which I will discuss later, hardware goes under patents, yeah, because those are inventions. You're looking at a materialized, a tangible object that has been created. So patents, when patents, okay, what I'm saying is this, some patents or some inventions or some hardware always move with software. It's difficult for these days to find an advancement that has no software. So you end up seeing that a patent to be fully functional, or an invention to be functional, it needs to have software in it. Because without software, a PC functioning, without a software, a phone will not function. So you need to always, even yes, hardware needs to always move with some other IP rights. Let me share with you my PowerPoint. Are you guys seeing this? Is this visible?
Still loading.
Hello? Okay.
Okay, it's now on.
Yes. So I'm discussing technology. How do you protect technological innovations? Of course, it takes time to how do you other forms of IP, like trademarks and the other. Let me see where that list is. So let me show you here. Yes. So forms of IP, besides technological inventions, there are other kinds of IP, like you mentioned. So you have patents, you have utility designs, you have innovations, you have trade secrets, which now goes under the NDAs you mentioned. You have trademarks, protecting and identifying feature of the company. Then you have copyrights, trademark works, source code, etc. And you have protection for plant varieties. Yes, these are the different kinds of copyrights, different kinds of IP rights we have in Uganda, that the world protects today. But I'll be discussing specifically because I was focused more into discussing inventions. And I'll start by giving a quote from Otafire. This is his forward that he writes in the Uganda National Intellectual Property Policy of 2019. This is the first national IP policy Uganda has had after a long time. People have always complained Uganda has no policy on IP. Let's implement one or let's pass one. And then last year, he introduced this one. And the comment is, or the quote he mentions within the forward, is Uganda's success in a knowledge-based economy is critically dependent on effective mechanisms for nurturing innovation and creativity. Many Ugandans are engaged in innovative and creative activities that directly benefit academia, public, and private sectors of the economy. Yeah. So what this shows is that as a country, Uganda is committed to protecting innovation or protecting people's creations. Yeah. So Uganda actually affords this kind of protections, as I will show you. So this policy is actually in place. It was passed last year, and it's actually operational. It covers all kinds of IPs in Uganda, all kind of IP rights, and it tells you how to implement protection and all the things are within the same policy. Yes. Technological innovations or technological inventions. I'll start by defining the key terms, which is technology or technological. The other is invention. Yeah. So technology, as we all know, it is a practical or industrial use of scientific discoveries. Yeah. It's the methods for using scientific discoveries for practical purposes. Yeah, in the industries, or the use of scientific knowledge or processes in businesses or industries, etc., or new machinery and equipment. Because for us someone what technology means, they will have to mention the different physical things they've seen. They'll mention maybe a phone, a laptop, some have seen smart TVs or TV itself. All these are forms of technology. Yeah? But for you to get protection under patent, the law sets some kind of limitation, some kind of guidelines that you need to follow to get protection under patents or other similar kind of intellectual property rights. An invention is defined within the IP, the Industrial Properties Act, as a solution to a specific problem, or in the field of technology, or a solution that is either a product or a process. So for you to get protection under Ugandan law on intellectual property, you must be creating an invention. The invention must be a specific problem, a specific solution to a specified problem. To find an invention that if you just come and design something that doesn't solve anything under IP, you don't get protection, because you must identify a problem you're trying to solve, then come up with a solution. So your design would be a solution to a problem. If you design things without having without having that element in mind, that problem, they'll ask you when you're trying to register, what are you trying to solve? Where is the problem? What have you identified as a problem? So you must always identify a problem first before you come to present the solution you're given. So technology innovations are product or process that solves a particular problem that you've identified in the fields that you want the law to protect you for. Or in these words, this is another interpretation: the process of devising or producing by independent investigation, experimental and mental activity, something which is useful and which was not previously known to be existing. The use of the word useful and not previously known are also defined within it, because the law says, why would you apply to protect something that already exists? So for it, a patent protection under the law, prove that the item you're trying to prove or to register is a solution to a problem, meaning it's useful, and then 2, it is solving a problem, and then 3, it wasn't before. So the first person to become an invention, it must be new, yeah? Prove that what you're trying to register is a new thing. If it's not new, you have no registration. They'll reject your application. Yes, so in the act, that same act, the Industrial Properties Act, defines what an invention is, and it says it must be a new and useful art. Like I've said, it must be a solution to problem. If you just come and design something without focusing, without looking at the solution it's solving, it won't be useful. So the item you're trying to create must be new and just be useful. And then the next one is it must produce a physical effect or not. Yeah, it may be a process to solve a problem, like if you're trying to find a step, you're trying to generate steps to solve a problem. For example, you want to maybe bridge a gap between communication. That is a process to communicate. You're bridging that communication gap. Or you're trying to create a machine, yeah, a manufacturing item, a composition. And then it must not be obvious. What you're designing should not be obvious. Right now, we are in the era of, let me say, smart TVs. Smart TVs, we have iPods, these things for Apple. So you have an item, you have earphones with strings, yeah? And someone comes up with an earphone that is cordless, it has no strings. Who would anticipate that an earphone would have no strings attached to it? Or who would anticipate that a TV would have internet connected to it? Or that a laptop would be the size it is today, yeah? So if you're modifying an existing technology, so it's a useful improvement of what is not obvious. So if you're modifying technology, you're reducing something in size, modifying how it looks, how it feels, how it produces, how it delivers a service to people. That is an invention, yeah? It must not be obvious, it must be new, because all the things we're seeing are new. A laptop was new when it came out. A digital TV or a smart TV was new when it came out. Right now they're old, but when they came out, the person that invented them got protection because it was a new invention when they came. This is just bridging the two terms together. You're mixing technological and innovation and invention. So technological invention is an invention that will be patentable. So you're looking at something that qualifies to be patentable as a technological innovation, which goes back to what the law in Uganda lays down to the requirements for you to apply for protection. Yes. So I would give a brief comment about Uganda's innovation right now, or inventions today. And from my research, you realize that Uganda has very little or low levels of registration of intellectual property rights. Many of them today that we have in Uganda are foreign, because you're going to look at, let's say, you're going to open a gazette where people publish before they actually approve their registrations. The gazette will show you that every item inside there is technological, is foreign. You'd find a page containing a trademark of Google, the Google map, or a Facebook logo, or Zoom icon, whatever. So in Uganda, very few technological innovations, but still the law to be, of course, to be in its compliance with international obligations, because I had to provide that framework to enable companies or businesses invest, come and operate within Uganda and beyond. So passing the law is a promotion to innovation or to innovation for foreigners and Ugandans. However, Ugandans are not getting enough to enjoy these. For example, between 2010 to 2016, the Trademark Act is of 2010. There was an older one they repealed. The IP, the Copyrights Act of 2006, Industrial Properties Act of 2010. But from 2011 to 2016, Uganda only had 47 patents registered. Low number its counterparts, as I will show you. So Uganda had very few patents registered in all that time, but the majority registered in Uganda trademarks. People are registering logos, identifying marks, etc., where the number was over 15,000. Then the other was copyrights, the 10 highest. Under the law, suppose, so the law says you design an article, it's a song, basically the law gives you protection to that particular copyright. You don't need to register your software to get protection. Automatically, the law gives you the protection. Yeah, but maybe the numbers, why the numbers are low, is because people actually know there's no need for you to register copyrights. Because, and I think that the biggest number of Uganda is creations today. People have more copyrights than any other kind of innovation. We have songs, not innovation, other kind of intellectual property rights. So many songs in place, so many books are being authored, so many softwares are being designed, but patents, to qualify to be a patent, it must be satisfying the text I've set behind it. It must be an invention, a tangible asset that is solving a problem, a technological element within it. So Ugandans have failed to actually come up with this kind of creations. They are there, but they are few. So the numbers are few, 47. But again, out of the 47, you'll find that majority of them are foreign still. Ugandans actually don't create much. Either they create much and don't register, or they don't create at all. And we have that gap in innovation in Uganda. Yes. In 2016 alone, we had one foreign application for utility models. It's another form of intellectual property. And then 2 of them were converted from a patent to a utility model. So a patent satisfies the patent be registered. It has some strict elements you must follow. And if you feel those elements are not met, usually the law gives you a lesser protection. So usually if you fail to fulfill an element, let's say an inventive step under copyright, you will go under utility model and the law will still protect you because it's a bit relaxed as opposed to patents. Yes, other jurisdictions. In the same year, when Uganda had 5 patents registered, Kenya had 207. South Africa had 7,000 registered patents. In the year when Uganda had about 15,000 trademarks, that range, Kenya had, I didn't have the partition. Yeah, so in 2015, I didn't have the number, but in 2015, Kenya had 2,666 trademarks registered. And Uganda, that we had 15,000 for all those 6 years combined. But Kenya in one single year, they had over 2,000 trademarks registered. South Africa had 4,000 and above trademarks. So our levels of innovation in Uganda are a bit remote compared to our neighbors. So the question would be, why do we have very few registrations? Why do we have very few identifiable intellectual property rights within Uganda? And the answers I found out were inadequate awareness of IP rights. People don't know about the rights IP offers them. Yeah, so people tend to create an item, assuming maybe someone. Let me use an example of NASA and Katwe. Yeah, someone makes a design in Katwe. Yeah, but that design is eligible for IP rights protection. But because they are unaware of these protections offered under the law, they need to register. So you get to see that people actually do not know which rights are existable or exist under IP right, and they never get to register them. The other is cost of registration. Some of these, the formalities involved in registering IP rights in Uganda are high. But some people would fear to register because they feel they can't afford to pay a particular service. They will tell you lawyers are expensive, so I can't pay a lawyer to register my IP. So I'd rather stay with it and register it. So you have so many people fearing the cost involved, or even the cost actually high, and people can't them, or feel they cannot really invest that amount of money to register an IP right. The other is the lack of capacity to identify what is an IP asset. Someone could draft, say, a poem of 100 words, and to them, these are just normal words. They won't know that under the law, a poem is protectable. Yeah. So some don't know that whatever they have before them is an IP right, an IP asset that should be under the law. So they tend to lack of awareness, don't know what asset an IP asset is. So they tend to miss that registration and miss the benefits that IP protection affords you. The other is few IP professionals and service providers. I don't know, because right now we have so many. In terms of, yes, I was saying right now we have so many software creators, yeah, but then very few professionals to support them. Very few lawyers are specializing in these fields to actually support intellectual property rights owners. You find that the providers of these services are limited in number, yeah? Or they even don't have the expertise to actually extend services to the creators, innovators, inventors. So the issue is we have very few guys in Uganda who can actually offer you IP protection or give you IP advice before you can benefit from IP protection. The other is inaccessibility of URSB to innovations and inventions in remote locations. So URSB has the office in Kampala, yeah, but you do not have a system that enables them to actually enforce any kind of IP rights beyond Kampala. They could be there, but they are limited, yeah. So you may find them in major cities of Uganda, maybe in Marara or Jinja, but you can't find them in some other deep-rooted places. But people actually are inventing, but no one protects them because URSB can't get to identify which kind of protections people have. It goes back to movements. The other is low level of stakeholder confidence in IP system, especially enforcement. So people know IP rights are there, some know IP rights are there, and they're actually now how to apply for their registration. But the question now comes, even if I register my trademark today, if I register my copyright, will the law in Uganda enforce? Because people say in Uganda we're good at making law, but enforcement fails. So people feel that even if they actually create these things, there will not be protection because enforcement is low. So because of that, people tend to come lax when it comes to protecting interests. The other is scarcity of funding for acquisitions. Someone comes up with, a startup comes up, creates, let's say, a product, maybe a medical equipment, but because they have no financing, they don't get to have their product blossom. So it gets stuck at breakout, at ground level. No one gets to support the things. So there's limited funding when it comes to IP. So because of that, people tend to undermine the potential IP has. So they get to ignore some of these creations and let some of these things die out. And because of that, we never get to have them registered in our systems. The other is marginalization of informal sector innovation. People in the informal sector, you tend to look at white collar, let me call them white collar creations, to ignore some other creations that are deep rooted in villages or that are not, that people don't feel up to. For example, someone could decide to protect an invention that, let's say, enables internet, or it enables, let me give an example of a phone. Someone could design a phone in Uganda and people are interested in the phone. But when to product that does agriculture, people tend to ignore. People get to put more focus on what they feel is white collar or is classy and stuff, and they ignore these low level innovations because they're too informal, yeah, and that those kind of miss out in these protections. The other is incomplete registration processes for trademarks. So you go to URSB, register a trademark, you make an application, and then before you actually have it completed, you back out halfway, either because the fees have gotten expensive or because you've missed out a technicality, or you have an element that you may qualify the full requirements for a registration. So you have people applying for registration, but they never get registered because they've backed out halfway. The other is, according to URSP data, 40% of people who apply for patent registration do not satisfy the requirements for patents. So someone with a patent, but because they meet, that they don't fulfill full requirements for the patent protection, they tend to, those applications killed, they're cancelled or put off the system. And like I said, if you have a missing element in a patent application, you can choose to go under innovation, or you can choose to go under utility model. But people tend to stick to, you go to strict requirements of patents, then you fail to satisfy the requirements, and then you stop there. You don't get to get your thing registered. The other is lack of respect for IP rights. Ugandan music, people don't have hope in the music, people have bias about our music. Someone releases a song, and people don't know that this song has IP rights in it, that the artist can actually benefit from it. But because of lack of respect for IP rights, people tend to ignore, tend to stick to pirating because they feel, why would I make a local artist rich over something that they don't find value in? But IP has value. Some don't see it, but the value is there. That makes IP protection difficult because people undermine the value in those particular IP rights. The other is too much copy and paste, counterfeiting. The example I had is NASA and Cartwest Hill. You have people who you've seen so many books on the streets being sold, novels, how to get rich books. But if you ask the people there if the actual owners of those books get these royalties to them, they don't. Someone comes up, does a photocopy of a book and begins selling in violation of the owner's IP rights. You have books that have, let's say, a book by Trump, but does Trump ever get to get his royalties? It goes back to enforcement. People counterfeit, they photocopy and sell. They counterfeit, they design a product, someone makes a Chinese phone or a fake phone and sells it, you're counterfeiting. So because of that risk, people tend to fear applying for IP protection, or they tend to they tend to create reservations about these IP rights, and that limits their protection under the law. This should have come first, but yes, these are the laws we have on IP protection. If you want to protect your particular intellectual property rights, the laws in place are these. You have the Industrial Properties Act that protects patents, utility models, designs, or tech innovations. Then you have the regulation that support the particular law that creates it. So the regulations bring out the enforcement. They bring out how the law will operate. Yeah. The other is the Trade Secrets Act. You have an act that protects trade secrets. If someone violates a trade secret, how do you penalize a person for violating a trade secret? Within the act, you'll find a mechanism that tells you can actually do a criminal file. You can file in a police and have an enforcement made. Someone stole something, a trade secret. Go to police, have that person penalized for the theft they've committed. The Trademark Act protects trademarks. The regulations support these regulations support you on how to apply for trademark protection. The other is copyrights, which sort of falls in mostly. And then Plant Varieties Act protects inventions in plant varieties. This grafting around, by grafting, you mix different varieties of plants to create something. Geographical indication, I meant right indications. Geographical indications, you have an instrument, an instrument that is purely Ugandan, for example, they are Congo for Itestos or Olekato. All these are identical. You can't have this kind of things found in Kenya. So the geographical indications. Now the law tends to also protect this kind of IP for the country. Yeah. The other is, which is the other good one, is a national intellectual property policy. The policy discusses all IP rights, tells you how to protect them, how to enforce their protection, what kind of rights exist, even to the kind of international conventions Uganda is party to, that you can actually use to rely on to seek protection under IP. Yes, for invention, I've been discussing technological inventions. That takes me strictly to Major Industrial Properties Act, which is an act to promote inventive and innovative activities, facilitate the acquisition of technology and the registration of patents, utility models, industrial designs, and technovations. Now, this law only protects those. Other laws are in place for other rights, but this is what the Industrial Properties Act protects. The policy is in place to provide direction, medium and long-term interventions that will enable stakeholders to effectively work together towards protecting and commercially exploiting research, innovations, technologies, and creative works. So with this policy, government showing a commitment to merge synergies. Your government encouraging partnerships between private sector, between the government, private sector, innovators, all those things. So this policy is in place to show you how you can actually tap into that kind of relationship between the different bodies. Who's an inventor? We discussed this briefly, but yes, an inventor could be an individual, the employer, like you mentioned, could be an employer in the company. It could be a person, an independent person who does his own creation. And also there could be two or more. The law protects an inventor as a person who can also be seeking registration as a group. Yeah. Two people come together and create an invention. Now these two would be called an inventor because it has a joint effort to create the invention. The employee, commissioned work. Someone is paid money to, let's say, create a software, a particular product. Once the software is done, it belongs to the person who commissioned it. That is an inventor of a commissioned work. But like I still said, all these rights exist, but at the end of the day, you still have moral right existing, that the owner is aside, but even the person who designs these products, the original author, retains the moral rights to be identified as the creator of these properties. You can't modify them to exclude that identification of the designer as the rightful owner. So as an inventor, what rights do you have? The first right is the right to be named as an inventor. Because you see, if you design, let's say, a calculator, and then you do not register it, and no one knows who the designer of this product is, how will they get to know who to pay royalties to, who to seek licenses from, who to communicate with when it comes to maybe a review about a product? So the first thing that IP rights protect you from is being anonymous. Yeah. So people get to know who the inventor is. That is the right you'll enjoy. The other is once you register your application, you automatically get a patent certificate, patent registration. So the moment you have a patent, that's already right, because it's proof that you actually own this particular item. Because, for example, if you wanted to borrow money from a bank, you need to show evidence of ownership. You can't say I need to borrow money using my trademark or my goodwill or my invention when you can't prove that you're the owner. So having a patent recognizes you as the owner of the particular design. So you also enjoy exclusive rights to make, use, exercise, sell, or preclude others from doing the same. So as an right to choose who you give access to your particular products, who you give rights to use, modify, all the things. It also gives the power to assign, like you mentioned, the IP assignment agreements, because you are an owner, you have the right to actually choose how to assign your properties. The other is I mentioned is the period for registration protection, which is 20 years. Once 20 years lapse, that right ceases to exist. Yes, so a patent has to be registered for you to enjoy protection under the law. So how would you protect your innovation? The thing is registered. Yeah, you can apply to register your. Like I said, registration makes people know that you're the owner. You'll do a song or a poem, and no one knows who writes poems. You'll do a graphical design for an art piece, and for one who designed the art, you start your design with URSB as the first enforcement you always need to have your interest, rights to ownership identified by the entire world. Yeah. So the first thing is register. So you apply to URSB, they register you. For patents, you also need to publish the registration, because once you apply with an application for registration, you need to notify the world, because remember the first test for patents is the thing new? Is it does it exist before you came up with the idea? So what publication does, the world has been designing this product and I'm going to register it for protection. If someone thinks what you're designing is not new and they have the idea before, they can issue objection and say, no, the idea is trying to develop into a material for registration, and I own it. So to avoid you losing your rights, a particular invention, you need to have it registered and publish it. You pay the fees.
Hello, Francis. Francis? I think we lost Francis a bit. Let's see if we'll get him back. Okay, I think Francis is off. We are going to just, let me see. I have a few questions to ask as we wait for Francis to get his network back. But maybe before I ask those questions, Rodney, I see you online. Do you have any comments to make so far based on what the two presentations have given us?
Yes.
Rodney, you are breaking.
Okay. Yeah.
Yes, Rodney.
First of all, thank you, and thank you for your.
Rodney, I'm sorry. We cannot hear you as you try to work on your network. let me quickly jump back to Ivan. Ivan, I know you spoke a lot before, but I had a question which I think many other participants would be interested to know. So we are talking about IP protection today, but are there any other practical ways to protect inventions for people who do not want to use the IP route? Francis has been talking about the fact that people are unaware about IP, or some of them simply have negative experiences from our IP. What can an innovator practically do apart from going through the IP route?
Okay. Maybe you could first. I think someone has background noise. Fit you.
Okay.
Yeah, other avenues. I don't really see any other way to enforce this kind of protection without involving the law. The only way someone can, because if you are going to work with a bunch of people that you want to rely on, then there must be some sort of structure to protect the information that you're working on. However, if it is a situation whereby maybe you are not yet completely, maybe you're not yet aware, or okay, let's try and eliminate the legal aspect entirely, then maybe you can say that we protect our information from external users, rather from external parties. So if I take out the people that you're working with entirely and do not consider those, because for those you have to have some sort of legal structure to protect you, and then we look at external people, then that's when it comes into what my last section was about, protecting your systems from being accessed by other people. If you have sensitive information on any of your machines, then the primary goal is to make sure that no other person without authorization can access that information. However, to really protect intellectual property, like on all angles, you must be able to make sure that, you know, in case someone tried to use your IP, then you would be able to pursue them under the legal umbrella, because I don't see any other way to protect that. You can protect access, and then you can also protect after the fact, you know, usage. So those are the only ways to protect your intellectual property. You're still muted. Yeah, you're muted. Okay, now.
Can you hear me now?
Yes, yes.
Okay. Thank you so much, Ivan and Joel, for your presentations. I'd like to go back to what you said, and this is what I realized. This is what I picked. If someone does not need to wait for formal registration procedures, let's say like going to URSP to protect their technological inventions, the protection of your technological inventions starts with you. It begins with you yourself. Like what you say, if I'm working on software, how am I protecting my software while I'm working on it? What am I going to do? Am I going to, you're a software engineer, there are ways you can protect your software from that. From a music perspective, sometimes they put DRM licenses. I mean, you can't use that song on an outside an application. This is like Apple Music. You cannot, you download the song, but the song will only remain in Apple Music. So you can go the technological way in the beginning, you know. And then there's also like what you talked about, non-disclosure agreements. If we are working on a project together, let us sign a non-disclosure. I mean, we're not going to reveal this information. Even basic meetings with potential investors. You have to sign a non-disclosure that you're not going to divulge what we're talking about to other people. Those are some of the steps. You don't need to wait to go to the USB office. And as lawyers, we also need to be aware of that protection of your inventions begins from these steps. What did you as a person, what did you as the inventor do to protect yourself? And you talked about something you said where you talked about if some securing the IP transfer, IP assignment. Now, if you're a company and you have software engineers, I mean, you want to own what they're creating. But now, if you do not own what they're creating, how will you be able to monetize that product? So you have to secure those IP assignments. Those under copyright is called work made for hire. There are those clauses in people's contracts that what you create, I actually own. Though your moral rights remain, like what you talked about, your moral rights remain that you are identified as the author. Same goes for musicians and record labels. I mean, when we sign a recording contract, what you're basically doing with the record label is you are giving them the ownership of your song. You can exploit it, and now if you don't secure that, how will you be able to make money? Because at the end of the day, how are you monetizing this IP asset? So if you cannot monetize that, if you cannot secure that IP asset using those basic steps, you cannot be able to monetize it. So when you've done those basics, those NDAs, securing the network, restricting access who has access to your IP assets, to your software, to your computer, then you're putting yourself in a better position when you go and formally register either under copyright, be it under a trademark, be it under a patent or utility model, whatever your lawyer will have advised you to do. But people need to know that IP protection and protecting their technological inventions, you don't need to wait for a lawyer to come and tell you that, oh, at the end of the day, you will need a lawyer to formally register and everything. But you can do some basic steps. Because my work will be made easier if you took some steps to also protect your assets. So for me, that's all for now. That's all I wanted to say. Thank you.
Thank you, Rodney. What I pick away from Rodney is the fact that you have to be very vigilant, you as the inventor, so that registration becomes a formal requirement. But I think I have Francis back. Let me see if I can get him to conclude.
Help me enable video.
Okay. Francis, back to you. Can you mute?
Sorry.
I'm getting feedback.
You get me?
Hello, Francis?
Yes. You get me? Hello?
Yes, we can hear you.
Yes, okay. I was saying I can't get you. Okay. Yes. So, like I was saying, is that the product you must prove everything.
Francis, we can't. I think you're still on mute.
No, I'm not.
Yeah, your audio input is just a bit low. Maybe you get closer or yeah.
How about now?
A bit
How is it now?
better.
Is it okay?
Yeah, it's a bit better.
Okay. So like I was saying,
Yes.
Francis?
Yes.
Yeah, Francis, we couldn't hear you there. Maybe you would speak louder a bit.
Let me.
Are you using headsets?
Let me pull them off. How is it now?
That's much better, Francis.
Okay, put headsets off. So like I was saying, yes, if before you register a patent, you must prove that it's industrially applicable. Yeah, because you can't protect any ordinary invention and you claim the law will give you protection for it. What you're registering must be applicable on an industrial scale. You can't, not like a pen. A pen is not an industrial kind of material. Yeah. It has to be industrially applicable. Like a gadget, a phone can be designed from a factory and it's released. A phone, all these kind of things are industrially applicable. So before you register for IP, for a patent, you must prove that element. The other is, sorry. Yes, yes. So industrial applicability, an invention shall be considered to be industrially applicable if by its nature it can be made in any kind of industry, including agriculture, machine, fishery, among others. Yeah, that's what industrial application means. Now, when it comes to registration, earlier I mentioned you have to go to URSB and do a registration. Yeah, that is for Ugandan protection. So intellectual property rights are territorial. What do I mean? If I register a trademark in URSB today, that trademark is only protectable within Ugandan jurisdiction. It doesn't extend to Kenya or China, whatever. That's why you get to see so many countries applying to bring their instruments or their IPs into Uganda. Because I've seen a gazette that shows a Google map, a Google logo registered, or a Google or a YouTube logo. So if you want to get your things protected abroad, outside Uganda, you need to apply for regional protection or international registration. And a regional protection, we have, so to enjoy regional protection, you have what we call a RIPO, yeah? Well, the first thing should be, if you have a country like you've identified China as a country where you want your IP to be protected, you can go there, go to China, register it. Go to India, register. Go to Kenya, register, which is unrealistic. But that's the first option. Pick individual countries that you want your thing to be registered in and register it. The other option is a regional application. You go to a RIPO and do a single registration, which will give you protection to all the 20 countries that are part of a RIPO. These countries include Kenya, Ghana, Rwanda, Tanzania, among others, Sudan, Somalia. So all these countries are part of a RIPO. So if you want to have your protection in those particular countries outside Uganda, you need to go to those countries individually or do an RIPO registration, and then it's protected. And to note, a RIPO has a Ugandan heading it. We have, I think, the former Registrar General of Uganda. What name is that? I tend to forget it.
Twebaze.
Yes, Twebaze. Twebaze Bemanya. Yes, the former Registrar General of Uganda is now the Registrar General of RIPO. So that's a good chance. It shows that Uganda actually have these kind of protections. and that the world is recognizing it. So by having a Uganda on board, we need to leverage that kind of connection to actually use that chance to extend our protection beyond Uganda. Yeah, we need to move out, go beyond Uganda, go to a repo, have your system registered, and in those 20 countries, this thing will be protected. The other is WIPO. Now with WIPO is a global version of a repo. A repo is regional Africa, and a repo is the global. So a repo has memberships. So if you want your system or your design or your intellectual property rights to be protected in these countries, you need to go to WIPO, and the registration will extend to all countries that are part of WIPO. China, UK, France, all those countries will have the same protection extended to them. But I think it goes back to costs, because can you bear the cost of doing a WIPO registration or a repo? Or you want to do an individual country registration? But to get your thing protected in those countries, you need to do those regional registrations. They're better than doing a single application. The other is infringement. So as you try to protect your rights, how do you know someone is breaching your right? And the test goes back to infringement. Is your right being infringed? And what is infringement? Infringement is a patent holder has a right to sell, distribute, modify. Some applies to copyright. A software designer has the power to share his rights with somebody else. A writer of a book has a right to sell the book to somebody else. Yeah. So if someone uses that power that you have under the law without your consent, then we say you're infringing. Yeah. So before you seek of any protection under the law, you must prove that someone is infringing on your right. If someone used, for example, if someone made a phone, Nokia phones are being sold, and someone sells a phone, instead of Nokia, it has an L, so you have Nokia. So having a Nokia phone moving around, it's confusing consumers that Nokia actually belongs to Nokia. Yeah. So identify the infringement part, then seek to protect it. So before you complain about anything, before you seek protection under intellectual property, you must first establish that your rights have been violated by someone. Identify the person. If you can't, identify the medium of the violation. If it's a website, you don't know who's violating it, but you know the site hosts this particular content, the site is violating. So you need to always identify that there's a violation first before you talk about protecting your interest. This is an enjoyment. Now this is under the law. The law says, the act says that in as much as you do an invention, some particular inventions cannot be patent protected, which is strange. But earlier we said an idea can be protected, which is clear. Before you put your idea into a conceptualized materialistic form, the law will not protect you. You need to always have it transferred to material first, and you seek protection. But if what you're trying to register is an idea, it won't get registered. If you're registering a discovery, a scientific formula, or a mathematical method, the law won't protect you. If you're trying to register human body parts, maybe you're claiming you designed a bone and the bone should be protected. That is a human body part. If you're trying to make an invention that involves human body parts in it, the law will not protect you. The last strange one, a controversial one, is pharmaceutical products. Right now, people are struggling to come up with COVID vaccines. But the law says the moment you do a pharmaceutical product, you don't have patent registration. You don't have patent protection for your invention. Under the Act, the law mentions from 2016, there's a period mentioned in the Act, yeah, and it already passed, which was 2016. When that period passed, WIPO extended the period to 2033. So if you make an invention within that period, that is a pharmaceutical product, within that particular period, you don't get patent protection. Other rights are there, but patents no. The law says no. You need to let everybody, because it's a public benefit thing. But patents are public. Pharmaceutical products are public benefits. People are trying to seek medication to treat, say, diseases, and you're trying to exclude access to the treatment. And the law says those kind of inventions should be available to everybody to exploit and treat. So there is no protection for them until that particular year. And I think when that year comes, they will again push it. And people tend to think, why would you restrict the Uganda, a low development country, from enjoying patent protection for, let's say, innovating an HIV vaccine? Yet Uganda and Kenya, Uganda and the US are in different categories. If that protection, that restriction applied to someone in the US would have made sense. But why would someone in Uganda and someone in the US have the similar restrictions? So Uganda, to promote Ugandan development, people are suggesting maybe let's have a system of, let's have this issue of pharmaceutical product registration suspended or removed for LDCs, low development countries, because they need to grow, develop more. We need to invent, maybe say they need motivation to create an HIV vaccine, motivation to do a COVID drug, yeah? Because if there's no motivation, IP gives you motivation. If there's no motivation, for example, restricting registration of patents for pharmaceuticals, people tend to lose interest in creating them. So they're saying, let's have this system limited to only LDCs and let other countries, let this restriction apply to them, but not Ugandans or not Kenya, because Kenya is a low development country. They're saying it's unfair, but yes, that's how the law is. You can't register a pharmaceutical product under patent. A secret, you can have a trade secret and it's protected. You can have maybe a utility model, it's protected, no, not a model. A trade secret, you can have an NDA signed, keep your creations confidential. But if you go under patent register it, they will not protect it. Or you can protect maybe a copyright. If you're claiming your particular pharmaceutical product is can't apply for patent registration, or under the Industrial Properties Act, you can actually register, let's say, a design, maybe a shape. You can have something on paper that gets copyright protection. Yeah, because copyright protects writings and stuff. Or you can have a procedure for treatment written down on a paper and seek that for registration, but not the patent, not the design that you're trying to make from the pharmaceutical product. Then how do you enforce? For enforcement, the first thing for enforcement is, like I mentioned, is you need to register. To enjoy the enforcement benefit, first register. Because by registering, people get to know who the owner of this item is. Without knowing who the owner is, you don't get the benefit of what you didn't register for. So the first thing is register. The other is that the country has commitment in protecting IP. So because of that commitment, we have laws in place. We have international obligations. Uganda is party to, and because of that, we have a safe space to create, because the law is in place. So already putting a law in place is enough sure that you're going to have your systems or your inventions protected or enforced in case an infringement comes up. The other is national, regional, and inter-country registration, which I've mentioned. Crossover, go to enforce your protection, crossover to Kenya, register your IP there. Go to Nigeria, register it there, or do a RIPO registration, or do a WIPO registration, and your things are protected globally. So to enforce protection there, I didn't have that written down, but you can also need to, if, for example, okay, I will show it in institutional enforcement. Then the other is remedies. These laws have remedies in place, yeah? Inside those, I'll show them in the next slides. If someone is infringing on your particular intellectual property right, how do you enforce? How do you complain? How do you raise a concern? And how does it get enforced? One of them is through URSB, institutional enforcement. With URSB, if you identify someone has used your trademark without your consent or copyright, someone is stealing your software code and using it for their own purpose without taking your consent, you can go to URSB. URSB you file a complaint to URSB, which will enforce. Either call the person who is infringing, or URSB has, if assuming what you're trying to claim is a trademark infringement or copyright, URSB in partnership with the Ugandan police have an enforcement unit for counterfeiting and pirating. Yeah. So if someone steals your software or steals your code, you can go to URSB. URSB in turn will go to the police, or you can go straight to the police. UPF, go to the police, file a complaint, and say they stole my copyright, they stole my trademark, they're misleading customers using my copyright or my trademark. Because within the Act, within the Trademarks Act and then the Copyrights Act, there are some laws, there are some criminal offenses created. Because the law says if someone steals, if someone misrepresents your items as another's item, that is an offense, and it puts a penalty, even including imprisonment. Yeah, they're also there. Even copyright. If someone pirates your software, you have a right to file a complaint with the police, and the police will actually enforce by arresting the person who is infringing. And if you go through the court system, they get a conviction. You have imprisonment for years, or you have imprisonment for a fine or a compensation to be made to the person who claims they've been infringed. The other is UCC. UCC is another good example. UCC regulates communications or media. If someone is uploading your content online illegally without your consent, you can actually approach UCC and say, google.com or monitor.com is using my images that I own without my consent. Help me enforce. Either they put the image down, Google or UCC will approach the company that is infringing, the online company infringing, and the company will put it down. Yeah, UCC will do that. UNBS standards. UNBS will make sure that if someone is the product someone is selling, Uganda National Bureau of Standards. If someone is selling, let's say a product, let's say soap, yeah. If before they sell a product, UNBS must say your product is worth or is good enough to go to the market. Yeah. So if you feel a product is in the market and it didn't have to be there because it's infringing on your intellectual property, UNBS can actually recall these products from the market because they're infringing on your property rights. The other is URA. This is mostly for importation and exportation. If you manufacture phones in Uganda, and let's say you have a particular logo under which the phones come from a company, if someone is trying to import a product that is infringing on your copyright or your trademark or your patent rights, URA can actually, through its enforcement mechanisms, block the clearances from those products from processing Uganda, leaving or entering. So URA is another good system. Then the judiciary is a court system. You go through court, you go through a civil remedy, you get your solution, or you go through criminal prosecution, you get your solution. Remedies are both civil and criminal. And strangely, within the Industrial Properties Act, I didn't find any offense that can get someone liable under criminal prosecution. It seems the law only avails person, the owner, remedies under civil law, not criminal. But for trademarks and copyright, like I mentioned, the law mentions criminal elements. So you can actually go to police and then file a complaint. But under Ugandan law, if there's no law creating an offense, you cannot have that offense in any court. So you can't even report someone for infringing on your industrial property rights if there's no offense in the law created and a penalty laid down. So in the Industrial Properties Act, there's no offense for violating, there's no criminal offense for violating industrial properties, which is unfair for designers or for innovators. But in trademarks and copyrights, they are there. There's a pirating criminal law, criminal element, criminal offense on pirating, a criminal offense on counterfeiting products. Then civil remedies, which is where mostly people under patents would fall, is civil remedies. Now for civil remedies, you can go to court and seek an order. For example, this also applies to copyright and patents and maybe trademarks. If you have someone who is trading products that are identical to yours, but they never got the information, you can actually go to court, seek a court order, and then get an injunction to restrain any violation. Yeah. For example, if you feel a radio station is playing your music, you can go to court to block the station from playing your music. If you find someone is selling your copyright, selling CDs with your CD with your software without your consent, you can go to court, seek an injunctive order to block the person from selling your CDs because they're getting monetary benefits which you don't get. The other is a claim for damages. You can say, because someone is doing this violation, I've made a loss. Yeah. If you can quantify the loss, you'll get a compensation for what you've lost. If you feel it's kind of, let's say, emotional torture or business damage, the business is being damaged, let's say the violation is damaging the company's reputation, you can do a claim for damages in the court. still it goes back to, these are all civil remedies available for violations. My last discussion is now the recommendations that come up with on how to perfect registrations of IP rights in Uganda. And the first one is create awareness. We say people are not aware of their rights under IP, so we need to create awareness for these rights by sensitizing people, speak to communities about their rights, speak to startup founders about the rights they have intellectual property. The other is introduce criminal elements for breaches. This is for, like I mentioned, under the Industrial Properties Act, there is no criminal element I noticed that directly applies to a violator of a patent right. So what you can do is, what I'm suggesting is the government should actually amend these laws and include a criminal element for patent infringement, which is missing, yet it's available in copyright and trademarks. The other is government and private individuals should invest more in innovation. We need to, even law firms need to do this, because you have, right now we're going so digital that if you're not in the era right now, you'll be left out. So firms, government, private individuals should put more investment in innovation. If someone in the firm, let's say, knows how to develop a software or a website or do code, fund the projects, fund their ideas. So let people in these government departments put in more contribution to encourage innovation. The other is more education and training in these fields. People like I said, we have an issue with a few IP professionals in Uganda. So we need to do more training, train more people on IP rights, go to schools. Schools right now have syllabi in IP. So do more school teaching, let people from the grass level know about their IP rights. And by the time they get to that level, they know what rights they're benefiting. The other is encourage research in higher institutions of learning. Research moves with innovation. If you don't research, you can't know what you're trying to solve. So research, find a problem, then research, find a solution. The other is review laws to cater for fast-changing innovations. Our laws are not catering for development. The Copyright Act is of 2006. It doesn't cater for. It's an old law. And today we have so many things that might need to be factored into that have changed. The other is what was it? Yes, amend the law to cater for those changes. For example, like I said earlier, that some patents, some technological innovations have or can't function without copyrights or without software into them. So a technological innovation usually works with a software. A laptop works with software, but the law as it is only protects softwares individually, protects patents individually. It doesn't provide for a joint. You cannot have a software patent, doesn't exist. Yet you have patents that actually have software in them. So what I'm saying is let the law modify to actually reflect that you can have a design, a patent that has software in it, and that should be given protection as a software invention, not a software copyright or patent, a technological design, but a software invention that combines both the patent and the software. It's missing in the law. So we need to modify that to reflect those changes. The other is define the extent of powers of institutions. The institutions I mentioned here, all these institutions, URSB, UCC, UPF, might have overlapping roles. So the law should clearly lay down and say, this is your obligation when it comes to IP infringement. This is what you do. This is your extent of power. It's missing. The other is empower URSB to enforce protection. If someone, say, is uploading an infringing product online, can URSB enforce it? And how can they enforce it? So we need to empower them to actually go forward to know how to actually take down a site that is infringing, because I doubt if they have that capacity to do that. Already you've seen them struggling with stopping videos of demonstrations from moving. This complaint they made to Google. So it means UCC has no capacity to actually stop these things from taking place. So we need to empower them, give them the capacity to know how to enforce their laws, enforce their mechanisms to protect intellectual property rights. The other is build institutional capacity, train judges. IP is very specialized. You need to train more judges on how to handle IP. We need to train more lawyers on IP, train people within URSB itself. They are there, they do something, but they don't fully understand some of the things. So we need to train them, give them more training in IP areas. The other is encourage dialogue within government and private sector, researchers, legislators, among others. Academia. Let government and academia work together hand in hand to encourage this kind of research in these fields. Yes, that's all I had for my presentation. So it took a while.
Wow, thank you so much,
Yes, thank you.
Francis, for that presentation. It was very rich and very detailed, and we've learned a lot. We're going to ask you to, in your free time, share with us that presentation. Maybe we can always refer to it. But you've covered everything from the background of IP right up to the enforcement, the modes of enforcement. And your presentation has sort of complemented on our earlier presentation. And I believe that we've done a good job in executing this topic. We will make the video, which I've been recording, available on our social media platforms and tag you in so that other people can be able to hear what you've been presenting to us today. Otherwise, I see that we are running short of time. We are past the 2-hour mark. And unless there are any specific questions, I'm going to thank you all for the participation and thank you for availing us your time. Thank you for being so kind and showing up on short notice. I do wish you a very lovely holiday. And from me and Simbel Advocates, thank you so much and goodbye.
Thank you too.